Good afternoon, everyone. Welcome to our webinar. I'm just going to give us a few minutes for folks to join before we get started. So if you'd like, you can say hello in the chat and put your name and where you're from, and we'd love to see that. Otherwise, just hang on a few more minutes. Hi, everybody, welcome. We're just going to give a few more minutes for folks to join, and it's great. Folks are putting their names and where they're from in the chat. If you just joined, we welcome you to do so as well. Great, well, we'll get started. Hi, everybody. My name is Sarah Gallagher. I am the Senior Director of the Erase project here at NILHC, and welcome to our third webinar in our Erase series webinar. It's great to have you here today. Today, our Ending Rental Arrears to Stop Evictions webinar series is focused on Preventive, connecting emergency rental assistance to courts and tenant protections. And we're so excited to have such a great array of panelists and presenters with us here today. So next slide. Before we get started, I do want to go over a couple of call logistics. Our session is being recorded today, as were our other sessions. So because of that, everyone is in participant mode, so you can't unmute yourselves. So we highly encourage you to use the chat function and the Q&A function for it. So use chat to give comments and to introduce yourself. And then if you have questions for our presenters and panelists, please use the Q&A function, which is on the bottom of your screen, to put questions in there, and we will be fielding them as we go, either live or we'll be typing in answers and sending them via the Q&A response feature. But we will make sure to get to almost all of the questions that are in there as we go throughout today. This session is being recorded and it'll be available online later this week if anyone has missed it, along with our past two webinars, so you can see them all on our website and get them later on. We'll be sending out links through our memo next week as well. Next slide. Great, so as I mentioned, today is our third in our three-part series. Today we have a really packed agenda, but this webinar, as I mentioned, focuses on preventive and state and local court partnerships and tenant protections. So we'll be highlighting strategies today that prevent eviction, that prevent housing displacement and homelessness. They're really offering flexible, holistic preventive interventions and creating formal partnerships with state and local courts. We'll talk about creating eviction prevention and diversion in coordination with emergency rental assistance programs. As you can see, we've got a great selection of national experts as well as local program administrators. We're first going to hear from Christine Stoneman on how courts can prevent housing eviction in crisis. We'll hear from Zackery Zarnow around developing partnerships from state and local courts to prevent evictions. And then we'll move into a panel discussion on supporting court partnerships at the local implementation level. We've got 4 great panelists who will join us for that. We've got Samira and Nazem, Jay Rose, Webb Brewer, and Greg Payne all joining us for that conversation. So we'll welcome them as we go forward. And I want to thank them in advance for being here. So next slide. So as folks know, this, or hopefully know by now, this webinar is at a very important point in time. Last week, the CDC extended the temporary eviction moratorium through October 3rd, and for folks who are residing in counties with heightened levels of community transition. While we're very excited and know that that is an important need moving forward, we want to give a little bit of information on that, but not understate the need to continue to create quality ERA programs and get funds out the door quickly to those most in need and create partnerships, because as I mentioned, this is in effect through October 3rd, and there will be a point in time where the moratorium is no longer in place. And so we want to make sure that we're using this extended time in the communities that it's available in order to create really well-rounded, accessible programs, as well as the partnerships that are going to sustain the work moving forward. So just a couple of highlights. The new moratorium, the big difference is that it is for people residing in communities with heightened levels of transmission. Many of the other requirements are the same. There is a new declaration for covered counties that is available online, but folks should know that people who have already submitted a declaration can still use that declaration and would not need to submit a new one. Next slide. The CDC has provided a tool to track counties that fall under the moratorium. So you can go to the website and look at the COVID Data Tracker county view, and it will show communities or counties that have heightened transmission at a point in time. And something important is that new communities can be added if they begin to experience substantial rates of transmission. And likewise, as we're moving towards October 3rd, communities may no longer be eligible if they don't have substantial transmission rates for 14 days. So there may be a little bit of inflow and outflow into this definition that we need to keep our eye on as we go forward. Next slide. Great. So this webinar series, as folks know, really is in line with our Erase call to action. Folks here at NLHC have been working with you all. We've been working with Treasury guidance. We've been working with UPenn and Furman on doing research, and other institutions to do research on really what are the best practices and innovations that are leading to successful emergency rental assistance programs. And we have been working to condense that into action items that states, localities, programs, policymakers can really focus on in the short and long term to ensure success. And so we have really developed strategies under a framework of 3 pillars: that the ERA programs are visible, that they're conducting equitable and robust marketing and outreach, that they're really ensuring that landlords, the lowest income renters, those already experiencing homelessness, and those with the most barriers to access are able to know about and to access programs. We want to ensure that programs are accessible, that there's equitable access and disbursement of financial support to both landlords and tenants, that application process is streamlined, it's low barrier, it's supported, and it moves at a pace that is able to provide support before someone or a household is evicted. And then the third pillar of the call to action, which we'll talk about today, is ensuring that there's holistic responsive interventions at all intersection points, especially around state and local courts, to prevent evictions, housing displacement, and homelessness. Next slide. In support of this call to action, we have worked to create erase checklists, and you can access those online at the link in the slide, and we'll throw that in the chat. And what these checklists are, it's a tool and there's a tool for each of the pillars of the erase call to action that will help you to do 3 things. We're hoping that it'll be a tool where you can sort of work through it and really to make a quick assessment of the emergency rental assistance program in your area, and is it meeting the components that have been found to support quality programs. It will help you to lay out attributes for program models, for program design, or for course correction as you go forward. And it'll offer strategies for program implementation and partnership development. With that, you can go to our resource hub and find examples of different jurisdictions that are using the different elements in the checklist. That'll be very helpful in implementing them. And we're always here to answer any questions or help provide support as you work through those checklists in your community. Next slide. So as I mentioned in the last slide, the checklists really talk about how ERA programs are working through various intervention points that people may go through as they're experiencing housing crisis or job loss that may lead to an eviction filing or potential homelessness. And we know that households in need and with multiple barriers really must be able to access emergency rental assistance at the time when they need it most. And that time is really defined by the household and where they are in the process and what they're experiencing at that time. So as we talk today, and you can just press the next button because I want to circle where we're at today. Where we're at today is really focusing on 2 parts of this process, the eviction, really focused on the eviction process and how it intersects with the courts. And so what we will want to talk about is ensuring that there's partnerships at all stages of the process so that we are flexible. We're offering emergency rental assistance multiple times so that people can have access to it multiple times, and that we're adapting the program model to work with the different point of intervention. Next slide. Couple of things we want to talk about before we hand it over to our presenters is that we at NLHC have talked about specific immediate state and local actions as well as programmatic actions that you can be working on now as we to build partnerships and as we work towards October 3rd and the time when a moratorium may not be in place. So we want to cover 4 strategies that we can talk about on the policy level, and then we'll talk about a couple of strategies on the programmatic side, administration side. So on the state and local policy actions we can be thinking about right now to prepare for the end of the moratorium is really working with your state and local partners to create or extend local eviction moratorium. With the newly surging Delta variant, we're really seeing that low vaccination rates and high eviction filings still are working hand in hand. So we want to make sure that we have eviction moratoriums that are protecting renters until vaccination rates are increasing in the communities most at risk. We want to make sure that programs have time to ramp up their efforts to distribute emergency rental assistance to households in need while they're balancing these concerns. Second, that brings us to our second point. As of the end of June, about $3 billion, or a little over $3 billion of the $46 billion in emergency rental assistance had been spent. And we've seen great trajectory in many communities of ramping up their disbursement of funds, of course correction to ensure that they're making direct tenant assistance available, and they're embedding other strategies that are enhancing disbursement. But we still see that many communities need to do more. They need to do to break down some of the barriers, and they need to streamline their processes to get money out the door quickly. And so we really want to encourage folks to use those checklists, to use best practices that will allow them to do so. The third area that we want folks to focus on are really adopting policies and procedural safeguards that assure additional time throughout the process. So ensuring that there's time for landlords and tenants to access ERA, that if folks do get assistance, that they have safeguards that while they're receiving assistance, they will not be evicted, or that evictions will be stopped if they were in the process, and that there's time through the hearing that folks have time to apply and move through the ERA process. And those can be policy and procedural safeguards that are put in place at the state and local level. And the fourth area is working to ensure additional rental protections around right to counsel, around developing and implementing policies to seal records that may be eviction records that may have been a result of COVID, so that people are not harmed for the long term. So we'll talk a little bit about some of these later in our call today. Next slide. So then on the ERA program administration side, we really, with the possibility of state and local courts processing and hearing a greater number of eviction cases moving forward, we really think it's crucial that ERA programs are building relationships with attorneys, with judges, with justice of the peace, with court staff to ensure that they're active partners in the emergency rental assistance process. So we are really encouraging increasing communication efforts in courts so that both the courts, the judges, and tenants and landlords know about ERA and have access to it when they are in the court system. Encouraging courts to modify summons information to include information on the ERA and ensure that it's available on websites as well. The information is available on websites as well as phone numbers and links to access the program. We're encouraging ERA programs and courts to think about data sharing so that they know who is in the eviction process as well as who's in the ERA application process. It's important to know that if an eviction filing is happening and if that person is in the process for your ERA, that a court system knows that, a judge knows that, so that they can plan and work with the tenant and the landlord to be part of that process. Likewise, it's helpful to know if a landlord hasn't already been paid in full and that the process has just not been, the eviction process hasn't been stopped, so that so that the judge can know that and can then stop the process and refer them back to the ERA program. We're really seeing many communities ramp up their presence in court right now, which has really paid off and been very fruitful. They're either virtually present or in-person present if that's happening and safety procedures allow, but really being there to offer community navigators to help do applications right there and then build relationships and fast track applications if need be. And then lastly, we are wanting folks to really take full advantage of the administrative dollars and the housing support dollars to increase staffing and build the infrastructure and ERA programs now, so that they're really strong and solid when moratoriums are lifted and the eviction courts are back in full process. That includes increasing staffing for housing navigation, for outreach, and for legal support to help people through the process. Great, next slide, please, sorry. And then the third pillar we'll talk about, which we won't talk about too much today, but we've talked about in other webinars and we're happy to provide more information about, is as eviction processes happen, some families or households may end up being evicted and may face homelessness or housing loss. And so ensuring additional housing stability supports, connecting with your homeless system and your continuum of care and coordinated entry process, and building the bridge to longer term or intensive housing stability supports is very important and crucial to ensure folks can be rehoused quickly if that is needed, and to help provide stability for the long term for households that may have additional barriers, may have chronic health conditions or a history of homelessness, or may need supports for a longer term. So really encouraging those partnerships with your homeless system and your more intensive support systems and health centers as need be. Okay, next slide. Okay, so just a reminder, this is where you can find our checklist. I think we also put it in the chat. Thank you. Great. So now I want to after that introduction, hand it over to Christine Stoneman, who is our Chief Federal Coordination and Compliance Section at the Civil Rights Division at the U.S. Department of Justice. We're really thrilled to have her here, and she's going to talk to us about how states courts can prevent housing and eviction crisis, and talk about some of the guidance that's come out of the Department of Justice recently, and how state partners and housing systems can really use that guidance to engage with their court systems. So Christine, I will hand it over to you.
Terrific. Thanks so much, Sarah. And I'm just so pleased to be here with all of you on this really important issue. So I would just say that Since March of 2021, probably longer than that, but that's how long I've been involved, the Department of Justice has been working in collaboration with our federal agency partners at HUD and CFPB and Treasury and other state, and also with the state courts and the National Center for State Courts, which is represented here, and the National Legal Aid and Defenders Association, et cetera. And we've been trying to focus on this space that Sarah was talking about, between where all that money is available, and Treasury, it sounds like with your input, has issued multiple rounds of guidance documents to try to lessen the burden on applicants to get that money. For example, allowing renters to self-attest to income and financial hardship. I know some local places aren't doing that, but that's what Treasury has put out, and promising practices, guides for ERAP administrators, et cetera. And CFPB has released an online tool to help renters and landlords access federal assistance that we can put in the chat, both of those things. So while those efforts obviously have resulted in a significant increase in the uptake of rental assistance, as Sarah points out, there's plenty more to do. And DOJ has identified time and diversion as critical components to avoiding an eviction avalanche if possible. So women and people of color will, of course, be disproportionately impacted as they comprise an outsized share of the renter households that are behind on rent. And women, particularly Black and Latino women, are evicted at higher rates than men. And Black households are more than 3 times as likely as white households to report being behind on rent, with more than 1 in 4 Black households reporting being behind. So with all of that in mind, the Department of Justice has taken several actions to try to help avoid evictions. I will say that all of you know, landlord-tenant law is, the purview of states and state courts, and so our focus here is on collaboration and bully pulpit, and of course, on using the federal tools and collaborating and gathering tools that we have available to us. So the actions have included one, which is steps taken to urge state courts to develop eviction diversion programs. And again, sort of the urging of the Department of Justice. And then 2, something we have a little more of a stick over, which is steps to prevent unlawful evictions, particularly where those evictions are related to discrimination. So maybe we can do the next slide. On June 24th, you don't have to read this slide. It's just to show you that this document is available for you to pick up and take with you to your local courts. And we'll put a link to it in the chat. On June 24th, the Associate Attorney General Gupta wrote to state court chief justices and state court administrators, encouraging the use of eviction diversion strategies to help families avoid the disruption and damage of evictions, and to assist landlords in collecting rent. Her letter highlighted specific practices that have been used by state courts around the country, including requiring landlords to apply for rental assistance prior to filing, extending time in pending cases to allow litigants to apply for rental assistance, and modifying summonses and other form filings to make litigants aware of the availability of rental assistance. The letter also reminded courts that of the $46.5 billion in emergency rental assistance that Congress had made available to tenants and landlords, the Treasury has issued guidance clarifying that these funds, along with the $350 billion in state and local COVID relief funding provided by the American Rescue Plan, can be used to help courts navigate the eviction crisis. And I will say that one of the things that happens with courts is often when they are, competing for big block grant money, they're not sort of at the table in the same way as some of the executive branch agencies might be. And so it was just really important for us to be able to highlight that this funding can be used to support courts navigating the eviction crisis, and that courts are eligible recipients. The letter also pointed to examples of tools of the National Center for State Courts, and you'll hear from Zach in a minute. And as I'll mention later, the letter flagged civil rights requirements related to housing and noted the HUD has also reminded recipients of federal funds of their obligation, their affirmative obligation to ensure meaningful language access for LEP, limited English proficient tenants, and to communicate effectively with tenants with disabilities. You can do the next slide, and that'll just give the link. The next slide. So the other thing that has happened is that the department, through the Associate Attorney General, participated in a White House evictions summit at the end of June. So the White House convened an eviction summit in which stakeholders from 50 different jurisdictions all around the country, including state courts, were brought together to share best practices and develop local action plans to keep vulnerable tenants housed. And the Associate Attorney General spoke there, and members of the Department of Justice helped with some of the breakout rooms. And then the Associate Attorney General, Vanita Gupta, went to the National Center for State Courts 50th anniversary convening on July 26th, where she spoke to the Chief Justices and state court administrators gathered there and emphasized the urgency to act. Among other things, she highlighted the eviction diversion diagnostic tool that NCSC launched, and you'll hear about in a minute if you haven't already heard, and how invaluable this resource is. And then next slide, please. Most recently in July at least, on July 30th, the Associate Attorney General issued a blog post, and this was designed to amplify through social media the sort of same points, addressing eviction crisis and reiterating the need to adopt eviction diversion strategies, the need for the courts to engage with community, with legal aid, with the ERAP administrators, with other folks around developing and pursuing eviction diversion strategies. In it, she noted that since her June 24th letter, so a month earlier, more than 24 court leaders from across the country had reached out to NCSC to discuss how they might address evictions crises. And also, we're in continuing conversation with court leaders as we speak. So the other piece I wanted to just share, and you can just take the slide down if you will, is that we are also taking action to prevent unlawful evictions in the first place. So we're working with the Fair Housing Act, as you all know, prohibits discrimination in housing, including in evictions, on the basis of race, color, sex, including sexual orientation and gender identity, national origin, including limited English proficiency, religion, familial status, having children under 18, or disability. And so in June, the Department of Housing and Urban Development issued guidance on this. We amplified that through our own messages. And HUD also reminded recipients of their affirmative obligation, as I mentioned, to ensure meaningful access for limited English proficient individuals and to communicate effectively with tenants with disabilities. So most recently, the Assistant Attorney General for Civil Rights, my boss, Kristen Clark, participated in a webinar, a tiny chat with Zach and one of his colleagues around the Fair Housing Act. And the focus of this is to help ensure that state courts, especially state courts that are dealing with evictions, can have that they understand the Fair Housing Act and how it can have an impact on people's fair housing rights in eviction cases. So many Fair Housing Act cases involve tenants who were evicted or threatened with eviction for reasons that are unlawful under the Fair Housing Act. I noticed actually today in the New York Times, there's the article about evictions in the New York Times that focuses on Las Vegas and other places. There was a sentence that really stood out to me, which was noting that landlords are turning to other reasons besides non-payment of rent for evictions. We need to make sure that where those reasons are unlawful and discriminatory, courts, victims, and advocates can issue a spot and ensure that their rights are vindicated. And so the housing section of the Civil Rights Division, HUD, and NCSC are working together to on webinars, on bench cards, and a number of other opportunities to do outreach in this area. And then I would just say finally, because I want to make sure that gets plenty of time before he has to get off, that Treasury has a page on how courts are using ERAP funds And we can maybe place that up on the chat too. And if not, we can definitely send it around. And that, that page is being populated sort of in real time. So if you know of examples where state courts are using ERAP funds to help prevent evictions, please be sure and let me know, or your folks at Treasury know, because I think it would be really helpful. One of the things we're really trying to do is information share here so that places in Los Angeles can adopt what's going on in Michigan, et cetera. So I'm going to turn it back over to Sarah. And thanks again, and I'd be happy to stay and answer questions.
Great. Great, Christine, that's great. And there's lots of questions in the chat for you, but I'm going to, because I know Zach has to jump off a little early, I would love to hand it over to Zackery Zarnow, who's a principal court management consultant at the National Center for State Courts, because we're thrilled to have him here to talk about his work. And then we will promise to get to questions after both Zach and Christine talk from the audience. So Zach, I'm going to hand it over to you now.
Thanks very much. And we didn't exactly coordinate it, but Christine and I are very much on message together. So this is going to work out perfectly. She teed me up for a lot of great stuff you'll see in a moment. So what I first just want to do is orient you by giving two kind of large considerations, two big things you should know about state courts so that you can have a productive conversation when you start talking with them about eviction diversion strategies. And I apologize if you know some of this, but I think it's worth reminding just so that we can really frame those conversations effectively. So the first is that courts, they're not a monolith. You really need to understand your local area and which court has jurisdiction over evictions in that area. And this can get kind of tricky. There are state district courts, there are municipal courts, there are mayor's courts, there are a lot of courts, and in some instances, multiple courts may be able to hear eviction cases. So you need to know first where these cases are taking place so you can go learn how you can work with them. The next thing to keep in mind is that in addition to courts hearing cases in some places and not in other places, there are certain judges that hear these cases and certain judges that don't. And there might also be a judge in charge of this docket, someone who's called a presiding judge or a president judge who kind of owns this process. But the judges that work on these cases can vary from place to place as well. So in terms of establishing a relationship, that's going to be different if the judges say rotate onto this docket for 3 months or 6 months or 1 year and then leave, versus a stable roster of judges that might work on only housing cases. Likewise, some judges might be elected, whereas other judges might be appointed. And so just as you would with any other advocacy effort or collaborative relationship, understanding where those folks sit, what issues matter to them, what kind of concerns and constituencies they report to is really important. And that doesn't just apply to judges, it applies to court staff, and I'll get to that in a second. Something else to keep in mind is that there are courts that reside within a system, and the system itself can vary from place to place. So in some states, you have a very top-down centralized court system, meaning that the Supreme Court generally sets the budgets and the rules for all the other courts beneath it. Whereas in other states, you might have a decentralized system where there's much more localized control. And so that local court has much more autonomy about its budget, but it can still interact with the local jurisdiction when it comes to legislation, county budgets, and things like that. And those court employees, like a clerk, for example, could be appointed, they could be elected, they could be a court employee, they could not be a court employee. And so I raise these considerations for you so that you really think about what your local court is like and understanding the nuances of that court so that you can have the most fruitful relationship possible. The next big thing to think about is the role that courts play and some of the limitations they work within. And so first is, this is obviously evident to all of you, I'm sure, but it's important for thinking about messaging. Courts must enforce the law. So perhaps your personal belief is that there should be no such thing as an eviction. But if you approach a court and say, excuse me, there should be no evictions here, they're going to say to you, well, in our jurisdiction, there's a law that says evictions can take place following these considerations and processes, and so we have to enforce it. And so that conversation is not going to be as fruitful if you approach them understanding that the court's never going to say, we'll just ignore the law because we agree with you, right? The next thing to keep in mind is that courts really truly pride themselves on being neutral parties. And so again, with your messaging, when you think about reform proposals or eviction diversion programs, a stronger, more often a palatable suggestion to a court would be one that doesn't favor one side or the other. So I know you'll hear from Samira soon about Cook County. For example, there legal aid is available to landlords and tenants in their eviction diversion program. Just offering up something that is neutral and supports both sides is a much stronger proposal to a court than one that necessarily favors one side over the other. The last thing I'll say on sort of this orienting slide is that courts do, of course, have some control over their docket, and whether they're in a centralized or decentralized system, that's true. But there are different ways they control that. There are rules, there are policies, there are procedures. In some instances, a judge may be able to issue an order and sign it, and that's it. In other instances, there might be a closed door committee that needs to decide on different changes to rules or procedures. Then it goes to public comment, and then it's enacted. And so understanding that process, that if you're trying to influence or change a rule or policy procedure, it's best to know the procedure by which they make those rules and how you can insert yourself and be productive in working with the court to make that change. So those are some orienting things to keep in mind as you work with your courts. And now that we have that foundation, I'm going to touch on a few things Christine did, and I want to talk about 4 concrete things that you can do with your local court right now. First is to offer to help. Like many other organizations, courts are under-resourced and overworked, and they need assistance. And they are doing a lot, but can your organization do more with them? Could you get information about rental assistance to them, or legal aid, or housing counselors? Could you allow, could the court perhaps allow you to, in either a physical or virtual space, offer intake or advice services in a waiting room or a self-help center? Could you put flyers in their library or lobby? Could you sit there and help people do rental assistance applications? And there are organizations that are obviously already doing this with the courts, right? Legal aid, bar associations, mediation. So those relationships exist, and you can work with them to work with the court. And so to start a conversation by first understanding them and then saying to them, and I'd like to offer assistance, is a great way to get a relationship built. Tiny chats were mentioned. Here's one right off the bat. If you're going to go work with your court and you want to offer help, this is a free public service announcement that we made that we'll customize for your court. We'll put their logo at the front end and the rental assistance URL at the back end, and we'll give it to them. And we've done that for about 26 jurisdictions, ranging from small municipal courts to large county courts to statewide systems. So if you're going to offer help, it's best to bring something in hand, and that's something you can take with them. And you can find it at that link there, which I think we can drop in the chat. The next thing you can do is keep them abreast of what's going on. As Christine mentioned, there are a lot of federal agencies working on this, but it's a lot for a small local court to keep track of. Can you be a resource for them? Can you help them understand that CDC eviction moratorium? Can you work with your partners to keep them up to speed on fair housing? Christine mentioned it, it's so important, and there are a lot of tools in that toolbox that exist to support folks working on eviction prevention. And neither one of these things is something that necessarily the courts are used to dealing with on a daily basis. So being a trusted partner who's offered to help, who's also bringing information to the table. And I'll give you 2 more things you can take back. First is another tiny chat. This is, we're wearing chef's hats here because we offer a recipe for courts to follow to respond to the CDC eviction moratorium order and to craft a court order that is responsive to that. And this was updated just a few days ago when the CDC released its newest moratorium. You can find all these at that one website. And then the second, again, on fair housing, and we work with Christine and her team at DOJ as well as HUD to offer some really concrete advice about the ways that Fair Housing cases, or Fair Housing Act can kind of work with eviction cases and to make sure your local courts know about it. So these are short videos, most of them are 10 or 15 minutes, and it's a nice way to provide information to a court and to educate yourself so you can educate that court. The third thing, and I'm sure we've all talked about and thought about this a lot, is eviction diversion. And eviction diversion is a powerful tool. And to help you create an eviction diversion program, at the National Center, we created a diagnostic tool. Think of it like a quiz. You tell it about your jurisdiction, you tell it about what your interests are, you tell it about the constraints, the funding, all sorts of partnerships who exist in your area. And it gives you about 10 pages of resources and guidance and best practices and examples from other jurisdictions that match your preferences and give you a concrete example to follow. And what I really like about this for courts is it's a game plan to set up an eviction diversion program. And what I really like about it for advocates is it's a framework for a constructive conversation. It grounds all the considerations you need to make. It has all those examples of guidance. And you can go to your court and say, you know us, we're the ones that offered to help. We're the ones that have been helping keep you abreast of all the different changes in eviction law and the moratorium. We like to think about an eviction diversion tool with you, or eviction diversion program with you. We use this tool and got these results. Let's talk about them. And it has all that guidance built into it in a really powerful way. And in addition to that, if you use the tool and you'd like to talk with us at the National Center about logistics, about setting something up, about questions you might have, we're also offering our services to you for free to chat about eviction diversion. And that can include doing things like working on legal information, helping draft orders or changes to notices or other things that the court might want to disseminate. So we're here for you, and that tool is a great way to start engaging with us. And then the last thing I'll say, and this is really the cherry on top, and Christine touched on this, there's money available. It's nice to be a partner that shows up and says, I'd like to do something with you. It's better to be a partner that shows up and says, I'd like to do something with you, and I know how to pay for it. That's a powerful message. So this is the website, the link we can put in the chat, but Christine touched on this. There was guidance from the Treasury Department in just late June, so just recently. But what it makes clear, and I've highlighted some sections here, these are things you can use that money for. And if you see the things in green, it's eviction prevention, eviction diversion, mediation, housing counseling, housing navigators, and legal services. That's an eviction diversion program right there. So my message to you is to work with your state courts first by understanding what they can and can't do, who they are, how they're situated, getting a relationship, offering to help, helping educate them, and then talk through eviction diversion, because these eviction diversion programs are not something limited to the current moment. These can be useful as courts manage their dockets moving forward for years to come, a very powerful tool to prevent evictions, to make this process work better for everyone. And at this moment, we have funding to pay for it. So I'll leave you with that message. I apologize, I do have to go, but I know Christine and others will handle any questions that might come up. And if you'd like to get in touch with me, I'll put my email address in the chat and you're welcome to reach out. So Sarah, I'll turn it back to you and just pause there, but thank you very much for the opportunity to speak.
Great, that was amazing, Zach and Christine. Christine, if you want to jump on back on for a second, I will. There's what great information. I hope folks are able to get stuff in the chat. There's a couple of questions that did come up that I'd love to pose to you guys. There were several that came up around what happens if state and local courts or judges are not recognizing or not honoring the moratorium. Like what do local folks do? What do states or localities do? How do they deal with that?
Well, I can take a shot at that. I just got actually off a phone call with a bunch of legal services executive directors. And one of them was the legal services executive director in Memphis. And many of you know, I think I saw something in the chat that the moratorium is enjoined in certain parts of Tennessee. And so one thing she pointed out is that courts, despite having no moratorium, the local courts in Shelby County have been granting 2-week continuances and providing triage space for attorneys who sit in the office in the courts, and then there's also somebody roaming around, and then they have a bunch of pro bono attorneys as well, or pro bono housing navigators. And so then legal aid determines where they are in the application process, and they can help decipher sort of what's next. And generally the judges are trying to help to the extent that they think they can, although they point out that they are elected officials and there's a balancing act. So there has long been a mediation program in Nashville that's been successful, but in Shelby, they're just sort of starting it out. I will say that they went from 300 evictions 1 week to 6,000 filed the next. So that may be, this is information that they provided me just now, and so that might be what we're looking at, right? I mean, that's really sobering. And so I would say that, there's nothing to prevent courts, no matter what they feel about the moratorium, from developing eviction diversion programs. They don't have to have anything to do with the eviction moratoriums, right? They can start out being about ERAP funding, but they could be more long lasting than that as well, right? So that would be my pitch, is this does not have to be a federalism issue. This is about how to best serve judges, landlords, and tenants.
Great. Great. I think related to that, a question came up around, you both mentioned that courts see themselves as sort of neutral parties in sort of implementing the law. So what sorts of arguments or persuasion has worked to promote eviction diversion programs as good for both the tenants and the landlords and for the court process itself? Are there sort of tips or sort of arguments or areas of persuasion that you've seen work?
Well, I can say that if you set up an eviction diversion program that assists landlords too, that's a pretty strong argument that it works for both sides. And we've seen that happen in a number of jurisdictions. And that's usually in partnership with legal aid. And these are smaller landlords who need the assistance, who haven't navigated a court system before. Another thing to do is to just work with the court on its own rules and procedures and think through what it actually says. There are a lot of things that are on the books that maybe don't necessarily get followed every time, or perhaps there's a wrinkle in there that people have sort of forgotten. And so if you understand what rules are required of the court in terms of checking to see if rental assistance applications are pending, or to make sure that service was actually given and so notice was given and somebody actually knows that they're subject to a lawsuit, things like that, you have a lot of powerful tools just in sort of holding the court to the standards it sets for itself.
Great. Great. And I think I'll just sort of say related to that one, someone mentioned that in Georgia, courts have been taking the position that providing information about ERA isn't permissible because it constitutes giving them legal advice. Is there any suggestions or things you would say to the courts in Georgia, or to our stakeholder here to say to their courts in Georgia about this?
So I would look at Illinois created what they call a safe harbor policy. It's designed specifically for court staff to help them understand the difference between giving legal information, which is how the game works, versus legal advice, which is how to win. And so those policies and procedures have been copied and emulated by many, many court jurisdictions. There are little cards, cheat sheets. I think if you're telling someone that something exists and they can go apply for it, that's not telling them how to win. That's telling them that the rules exist and that's the way the game is played. It's one thing to offer them advocacy help, but it's not legal advice to simply say that these are resources available to you and here's where you go find them.
And I would just add to that a persuasive voice on this is Chief Justice Hecht from Texas. And I think that he mentions this in your tiny chat, Zach, from over a year ago, maybe, that, one of the things they did there, because justices of the peace are dealing, hundreds of justices of the peace, and they didn't know what they could say or not say. So they actually dealt with that directly in their order. The order is no longer available, but justices of the peace are still able to give this information. And sometimes a judge hearing that from another judge is a nice thing.
That's great.
Agreed.
That's great. Well, I want to thank you both, Zach. I know you have to run to another commitment, but thank you so much for being here. I'm sure folks will reach out to you. This information was so valuable. And Christine, if you'd love to stick around, that'd be great. I know there's some more questions in the chat. If you have a second, if you want to answer some, that's great, or we can get together later and answer them. But thank you both for joining us today. This was wonderful.
Thanks very much. Bye-bye all.
Great. So next we're going to turn it over to our panel discussion on court engagement to prevent eviction, and really hear from some strategies that are having great impact at the state and local level. Our panel today consists of Samira Nazem, who's Associate Director of Programs and Advocacy at the Chicago Bar Foundation. We have Jay Rose, an eviction prevention consultant, Webb Brewer, General Counsel for ERA in Memphis and Shelby County, and Greg Payne, who's a Director at the Maine Affordable Housing Coalition. So I want to welcome you all to our call today. We're going to start off our panel discussion hearing from Samira from the Chicago Bar Foundation. And so what we'll have format today, we'll hear from each of our panelists, and then we will open it up for a kind of a discussion and Q&A as time allows. So Samira, I will hand it over to you.
Thank you, Sarah, and thank you for having me here to speak today. It's really great to be with everyone and to see how much enthusiasm there is for setting up programs like this. And I'm sorry, Sarah, are you able to advance my slides? Perfect. Thank you. So as Sarah said, my name is Samira. I work for the Chicago Bar Foundation, which is obviously located in Chicago. And we also work with our circuit court in Cook County. And I'm here today to talk about a new program that we've established early in the pandemic, which is aimed at combating housing and financial instability among Cook County residents. We love acronyms here in Chicago, and the name of our program is CLAD, Cook County Legal Aid for Housing in Debt. Next slide. So I won't dwell too much on the background here. I'm sure you've all kind of gone through similar conversations in your jurisdictions, but early in the pandemic, we started to see that we were going to have a wave of eviction and consumer debt cases and needed a coordinated response to make sure it didn't overwhelm our courts and our legal aid providers and legal community more broadly. Next slide. So first thing we had to do was kind of take a look at how our court system was functioning. Even before the pandemic, we were really stretched thin in a lot of ways. Like I'm sure many of your jurisdictions experience, we had huge numbers of eviction cases pre-pandemic, about 30,000 filed every year in a very decentralized court system. We have 6 buildings. We have our main courthouse in downtown Chicago, but we have 5 suburban courthouses as well. And there was a lot of variation in how cases moved in through different courtrooms and courthouses. Like other jurisdictions, we had huge disparities in legal representation, where the overwhelming majority of landlords were represented by counsel, but the overwhelming majority of tenants were not represented by counsel, and we're having to navigate that process on their own. And of course, like so many other jurisdictions, there were huge racial disparities in our eviction courts. We have a ugly history in Chicago of racist housing policies and practices, and the legacy of that is still very real today in the disproportionate impact of eviction and housing instability and housing affordability on communities of color. So moving forward from kind of where we were and seeing all the problems that we had in place, we needed to take stock of our existing resources and figure out how we could increase their capacity to do more. We had a lot of services and supports in place before the pandemic. We had mediation, legal aid, self-help centers, self-help forums and resources, and lots of wonderful resources, but they were very decentralized. So it could be very difficult for people to find them, even if they did exist. There were certainly not enough to go around. We have nowhere near the number of legal aid and pro bono attorneys necessary to meet the need. We had many high default rates. So even if we had resources available at court, too many tenants were not showing up at court to take advantage of those resources. They were simply opting out of the process altogether. And then we had a huge disparity between what services were available at our main courthouse in Chicago and at our suburban courthouses. People often think of legal deserts as being a uniquely rural phenomenon, but even in a large city, in a large county like Cook, we have huge discrepancies between the ability to access legal counsel depending on where you're located in the county. And again, as I've mentioned before, a very decentralized process that made it hard to advise people since it looked very different from courthouse to courthouse. And so from all of that, we realized we needed a better, more coordinated, centralized effort to move forward. Our kind of ad hoc piecemeal approach wasn't going to fly in the face of such a big challenge. And so the idea for CLAD was born. So this is a partnership between our county government, our circuit court, the city of Chicago, and a network of legal aid and pro bono partners who are listed here, as well as a network of community outreach partners as well. And the program involves multiple parts. I'm going to focus on the eviction part today, obviously, but I do want to mention also that there's a consumer debt part of it as well. We run our program in 6 different eviction courtrooms throughout Cook County and in 6 consumer debt courtrooms as well, realizing the intersection between housing instability and financial instability, and many people who can't pay their credit card bills or their medical debt are ultimately going to fall behind on rent too. We wanted to really tackle both of these problems simultaneously, and the structure of our court made it fairly straightforward to do that because all of these cases are heard in the same division of our courthouse. We're also launching a foreclosure program later this year as well, because we do see how intertwined all these issues are, and we want to make sure we're serving all of the residents as best we can. So this is kind of a quick timeline of how our program works. One of the key aspects of it is we wanted to create multiple entry points, knowing we're not going to catch everyone at the same moment in time. So our goal is always to get people into the program as early as possible, but also to have safety nets in place for people who we can't catch before court. So we have a pre-court component of our program. We run a hotline, which is staffed by attorneys and operates 9 to 5, Monday through Friday, where anyone can call and talk directly to a lawyer to get advice and to get kind of referred to the network of legal aid partners that are in the program. We also have a network of community outreach partners who are helping us with kind of the community level awareness of the program to make sure that people understand that there is a resource that exists and that they can hear about it from trusted community partners. If we don't catch people before court through our hotline or our community partner network, we have an in-court component as well. Now that when everyone comes into our eviction courtrooms, their first court date is a case management court date where they have an opportunity to speak with a case manager for our program, who will screen them and match them up with a legal aid partner or a mediator or both, to make sure that they're able to get the advice they need to reach a resolution and to advance their case. Our case managers are also able to connect them with rental assistance programs, which are constantly opening and closing. It can be very hard to keep straight. Our case managers are always trained in how to kind of make those connections in the best possible way, given where we are at that moment in time. I do want to also kind of highlight, Zach mentioned this earlier, that one unique aspect of our program is that we serve landlords and tenants, as well as debtors and creditors. It was really important that this be a program that was available to everyone, whether they're filing or responding to a case. And we had also seen that the pandemic had taken a toll, especially on smaller landlords who rely on that rent to pay mortgage or to take care of their families, and who were really struggling as the moratorium went on, and they were falling kind of further and further behind. We've seen that that's been particularly challenging for some immigrant communities as well. So we're really grateful we've been able to provide those resources to the small landlords, especially landlords who have language barriers or kind of other challenges that make it particularly frustrating to navigate the system and understand the kind of layered local, state, and federal moratoria that are all in place. Whether someone accesses a program before court or during court, our primary goal is to resolve the case in the least harmful way. When possible, we want to try to connect people with rental assistance and work out an agreement where they can stay housed and pay back the landlord. If ultimately a tenant is going to have to move out, we want to find the least harmful way to do that by getting them time they need to move out with dignity, by sealing records, by reducing back rent owed, and doing anything we can to make that a more an easier transition and to avoid that stain of having an eviction judgment on someone's record. Our legal aid partners are also able to screen for cases where it may be necessary to provide an extended representation service, and it's not a good fit for some kind of settlement or early resolution. Those cases will be referred out of our program and can go to one of our legal aid partners in Cook County, where they may be able to get extended representation, either preparing for trial or for some other substantive litigation in that case. So just again, to highlight a few of the key aspects of our program that have really changed how eviction court runs now from how it looked before the pandemic, is that we have a centralized process now, rather than having every court and every judge kind of manage their calls differently and providing different experiences for litigants. Everyone is on the same track, where everyone starts out at an early resolution case management call through the CLAD program and has the ability to access the same resources no matter which courtroom or courthouse their case is filed in. We've created one entry point for accessing our network of legal aid partners. So beforehand, where a litigant may have had to call 8 different phone numbers, schedule 8 different intake interviews in the hopes of connecting with one legal aid resource. Now there's just one hotline for entering into the program, and a whole network of people are able to provide services through that single entry point. And lastly, we're using Zoom to provide services remotely so that we can scale them up, serve every corner of our county, and try to make this program as accessible to as many people as possible. And our court partners have set up Zoom kiosks so that for individuals who do not have the technology to use Zoom from home, there are various points throughout the county where one can go to access Zoom and get assistance logging on for free. So kind of in conclusion, this is, again, just an overview of who we help. This is a screenshot of the program website where people can go to try to reach out before court, either online or by calling the hotline. We're serving tenants and landlords before and during court. We're serving homeowners who are behind on their mortgage or the condo assessments or property taxes, and people who have debt issues, both creditors and debtors. So it's really a wonderful program where we're able to provide a lot of services to different people across the county who have been strained by the pandemic in different ways. So I think I'm probably over my time now, so I'll pause there, but happy to answer any questions about the program too. Thank you.
Great, thank you so much for that. There's one question I was going to ask you actually before we moved on that came previously, but I think that you might have great insight about this, because so when thinking about, actually, sorry, wrong question. When thinking about creating a standardized approach for court systems and eviction processes. You talked a little bit about centralization and one entry point, but what do you think are some of the best practices that other folks can think about when standardizing a process, an internal process for court systems?
So when we were trying to think about what the standardized process should look like, I mean, we really relied heavily on our legal aid partners because they're the ones who practice day in and day out in those courtrooms and have a really good sense of kind of what the best practices are and where they've identified specific practices that pose challenges to them and to their clients. And we really tried to listen to them to get a lot of feedback about what this process should look like. We also made a point of reaching out to representatives from the landlords bar too before we suggested implementing anything, to provide them opportunities to provide feedback, since sometimes their goals may not be completely aligned, and we did need to be responsive to the needs of both the tenant bar and the landlords bar. But really, the thing that everyone agreed on is we just need consistency and clear communication about what to expect. And some of the practices that may have flown when people were in person, where you could just show up and ask a clerk, how does a judge like to do this or that or the other, didn't translate well to Zoom, where there was no opportunity to have a side conversation with the clerk about how an individual judge preferred to handle a matter. So we really needed a way to set standards and to communicate those standards to all stakeholders, to both attorneys and litigants.
Great, thank you, Samira. That's wonderful. Such impressive work. Again, stick around for us. There's some questions in the chat that if you want to take a look at, and then we'll get back for questions and answers if we have time in a little bit. So thank you so much. Next, I want to hand it over to Jay Rose, an eviction prevention consultant who's been doing some great work with wind companies and others across the country. So Jay, I would love to hand it over to you to talk about some of the work that you've been leading.
Sure, thanks. A word about me. I retired about 1.5 years ago after 40 years as a legal services housing lawyer in Orlando, Florida, and Boston. And upon retiring, I met with folks at Wynn who I've known to talk to them about developing an eviction prevention plan that made good business sense. I picked them because I represented tenant groups who had negotiated with them in Hope 6 and expiring use deals. And at Castle Square in Mission, Maine, the tenant leaders are now managing general partners in a 50-50 partnership with Wynn. So I knew that they cared about affordable housing. The good business sense was, and this is primarily based on project-based Section 8 and tax credit, although many elements also apply to market rate housing. Next slide. Wynn, by the way, as I said, is the largest manager of affordable housing in the country. So if this works in Boston, it could expand outwards. So the goal of Wynn companies is to lower eviction rates for non-payment of rent by 50% over the next 5 years, and to do so without losing money. This started pre-pandemic, started 3-4 months before the pandemic. So by the time the pandemic hit, Wynn was geared to try to implement some of the elements. The next slide. In terms of upstream, I don't like this home sweet home title, but I love the notice itself. When tenants move in, there's in affordable housing, there's hundreds of pages of documents. People can't read it. They don't know what's going on. So what they do is come up with a one-pager, which is on the right. And right in the beginning, they tell people, we expect, rent's due on the 1st, it's late by the 5th. But they also say, if it's easier for you to pay weekly or twice a month, as opposed to monthly, we'll do that. As a legal services lawyer for years and years in settling eviction cases, we'd always try to get landlords to say, well, we get paid twice a month. Can we pay you twice a month? The answer was always no. So the Wynn plan has a bunch of essential elements, each one little, but all put together will save evictions. And right away, if you look at the bottom, legal counsel, right to counsel. So the first day is if things don't work out, you don't like the way we're treating you here, you could call your local legal services organization. And in the small print later on the right, it talks about 3 of the most essential elements. One is interim recertification. For project-based Section 8 tenants, Why don't we go to the next slide and we'll look at that. The regs say, and the law has always said, that if a tenant loses income, they don't have to report it immediately. But when they do report it, even if it's 3 months later, even if they don't tell you they lost income until you're suing them for non-payment or rent, the regs say that you not only can, you need to recertify to the first month after the loss of the income. No 30-day rule. So if it, many owners, if it goes on for 3-4 months, they say, well, we could only do retroactive for a month. So by imposing this even before the pandemic, when the pandemic hit and tenants couldn't pay, they already had a mechanism to go in and bill HUD, and HUD paid the difference, paid everything if it was a zero income. Next slide. Training of managers also has to do with expensive, and trains all their managers to approach it like a housing advocate would, like a legal services lawyer would. What are all the deductions we can use? Did we get everything? How can we otherwise lower the amount of rent that the tenant has to pay so that HUD would pay what they should pay? Next slide. Okay, so when the pandemic hit, WIN was singularly situated in order to help tenants apply for rent assistance when all the various formulations of aid came down the pack. And one of the problems was it takes so long, right? Well, why does it take so long? So WIN decided that they had all the information they needed, and the expression was pre-populated. I never heard that before, but pre-populated with all the various agencies in Massachusetts that processed rent payments, and some of these were state programs and federal programs. So they already gave all the information for all their properties to every agency, so that when they found out that a tenant was behind, before going to court or anything, this is all upstream, they could expedite the payments. They also had about 90% of all the information that the tenant would submit in their files. So they would, if you look, third bullet, for non-paying households who failed to make contact by the 15th, they would assemble the rent assist applications on behalf of the household. They had 90% of the information, and they would then reach out to the tenants and try to get them to just say, okay, submit it. And next slide. Another part was in-house payment agreements, where and this is really important. We look, the payment agreements that were supposed to be affordable, achievable, and sustainable. So in the past, a lot of times someone 3 months behind in the rent, and they go to court, and the eviction lawyer sort of says, well, we'll let you pay it back, but you have to pay it back within 3 months or 4 months. Well, if someone couldn't pay $600 a month, in rent because other things happened, how are they going to pay it back by paying $1,200 a month? Plans that were doomed to fail. So now the managers and eviction lawyers will be instructed that they up to 12 months, if that's needed, to come up with a payment plan that can work. Obviously, the managers would like it faster, and in some situations, if 12 months doesn't work, senior management can approve that as well. And the deep dive means that it's really based on income and expenses, all their income. It's got to work for the tenant. And why does this make sense? Why is this good business sense? Because in Boston, a couple of years ago, the average amount of rent due was about 3 months behind in rent for a subsidized tenant being evicted for non-payment, about $1,700 or so. It costs between $4,000 and $8,000 to evict a tenant. Why is that? Well, because once you evict them, you're never going to get the $2,000 that they owed, right? So that's gone. Plus, you're going to have to pay lawyers to evict, constable fees, put the stuff in storage, fix up the apartment. It takes a month or two. You don't get any rent from HUD when it's empty. So you're saying no to someone who's got 6 months to pay it off, when in fact it costs you $4,000 to $8,000. That was something that was counterintuitive to ownership, and WIN was able to see that really quickly, that it made good business sense to come up with reasonable payment plans. Next slide. You can look at this slide, but the main thing about legal counsel is eviction lawyers often see their job is to evict, right? So Wynn has instructed them that 1, treat residents with respect at all times, even in court. 2, focus on tenancy preservation, not eviction. 3, there's an understanding that pro se tenants are at a disadvantage, right? And not only a disadvantage because the owner has a lawyer, but some tenants have language issues, some mental health issues, other barriers. And so eviction lawyers are now being instructed to be mindful of that and to refer tenants to legal services, attorney of the day programs, or nonprofits that can help out. But there's another issue being adopted, rep payees. A lot of tenants have problems with money management, and you know, even if they haven't lost their income, expenses greatly outweigh take-home pay, et cetera, right? Even for folks who are on welfare or unemployment comp. So they sometimes need money management. Well, if you're on Social Security disability, you could get rep payees. So what Wynn has decided is that if a tenant says that they can need some help managing their money, Wynn will pay what often costs $25 a month for the tenant to have a private rep payee to help them pay the bills, et cetera. And that will come out of their share, not out of the tenants, because folks on limited income, even $25 a month is too expensive. Again, interim recertification back to the first month after losing things. And if there's a repayment agreement in court, if the tenant loses income during the course of that payment plan, the settlement agreement, then Wynn will reevaluate and renegotiate the monthly payments. That's unheard of these days. In terms of defaults in court, which happens way too much, Wynn is going to be allow tenants to name third-party folks, whether it's relatives, social service advocates, who will get notices once it's in court of all motions and court dates to lessen the possibility of just folks missing it because they didn't know about it. And there also will be performance evaluations of all eviction counsel going forward. Next slide. So far, what has this done? Wynn has been working in 11 states to help state administrators, work out these plans. They lowered their notice to quit issuance by 99% in the last couple of years by requiring senior management to approve any notice to quit, train 3,500 staff members, and we're in the process of training 150 or so private counsel. And one of the major pieces, how does this work, is it used to be someone's behind in the rent, you send them a notice to quit, and then you wait to see if they pay and then file in court. The Wynn plan has 9 places after the 5th of the month where they offer assistance to help the tenant apply for rent or see if they need to enter recertifications, et cetera. In the last couple of years, I mean, even during the pandemic, all these efforts, look at this, collections exceeded 2019 projections for 2020 at 92% of the properties when balanced with confirmed ERAP funding. So when you add in their efforts of getting HUD to pay and for helping tenants apply for funds, they've done well. They've hit 92% of what they expected pre-pandemic. And they've completed over 21 million in ERAP applications, helping 10,000 families. And the last part is the most important long range, is cultural change within the organization. Management at Wynn it used to be that for managers, accounts receivable was the goal. And managers would get bonuses in part based on rent collection. Now that still will be part of it, but also managers will be getting bonuses based on lowering eviction rates. So that's all I got. Thanks.
Great. Thanks so much, Jay. What great information. A question that did come up in the chat, which I wanted to ask you, was, are wind companies allowing for repayment plans of COVID-related arrearages longer than 12 months? And if so, are there any legal issues with that, or any waivers that needed to take place to make that happen?
I'm not sure the question. I mean, in general speaking, they would allow over 12 months if that's what's need. Most of that, I don't know the answer to that question. They want to do over 12 months. If they're getting payments from ERAP, that pays it all up. So most of the payment plans, we're not talking ERAP, we're talking pre-pandemic and post-pandemic.
Great. Great. Thank you. There's a few other questions in there, which we'll get to if we can, but take a look. I want to, though, give time for our other panelists. So I'd love to introduce Webb Brewer to our stage. Webb is a general counsel for ERA at Memphis and Shelby County Emergency Rental Assistance Program, and been working in a really interesting environment on their eviction settlement program, in an environment that actually hasn't had a moratorium, I think, since March. So might have some experience that folks will find helpful. So Webb, if you are still on the line, would love to introduce you to talk with folks.
Thank you, Sarah. As Sarah said, my name is Webb Brewer. I'm the general counsel for the Neighborhood Preservation, Inc. Emergency Rental Assistance Program in Memphis. We're a part of a bigger ERA program, the Memphis and Shelby County ERA, but we do all of the legal representation. We focus on eviction prevention. So that's our bailiwick. Next slide, please. Just a little background on Memphis for those of you that aren't familiar. We're a poor city. We have a poverty rate of 21.9% and the lowest Black home ownership rate in the country, one of the lowest home ownership rates overall. So we have a whole lot of renters. Historically, even pre-pandemic, we had a high rate of evictions. In 2019, we had an eviction rate of 4.9%, which is more than twice the national average. And finally, as has been mentioned, we're a canary in the coal mine, so to speak, in that we have been without the CDC halt order protection since March. We were one of the cities where landlords filed suit questioning the constitutionality of the halt order. We filed amicus brief along with a couple of other entities, National Housing Law Project, and helped keep injunctive relief from going in. But in March of this year, the federal judge granted summary judgment finding that the CDC had overstepped their statutory authority. Next slide, please. One of the things that helped us a little bit, mitigating factor, was that our courts were closed for a while. And then when they reopened, it was on a restricted basis. Only a portion of the dockets were held in only half of the divisions, really. Unfortunately, and that kept the number of eviction cases we were seeing down. Unfortunately, as of August 1st, the eviction dockets are open full throttle. And so we've seen an increase of eviction cases being heard from about 750 to around 3,000 per week. Like in many of your jurisdictions, there's been little balance of power in the eviction courts in Memphis. landlords are represented 90% of the time, and tenants are represented at only 5% of cases, and most of that is our attorneys that are appearing. One bit of good news, though, is that despite all of this depressing information, 59% of the time since March, courts have denied judgments for possession. And we feel like that is largely the result of our work. It would have been more like 100%, I think, but for our ERA program. Next slide. We have a very hands-on approach to evictions. We have 5 attorneys on staff who are in the courts every day, in every docket, in every division by and large. And how our program works is that if a household applies for rental assistance and they have an active eviction case, we pick that up and collate the applications with eviction dockets and appear in court on the first setting to request a continuance. Under Tennessee law, judges can allow a 2-week continuance on the first setting. Then attorneys will reach out to landlords' attorneys and offer to pay all of the back rent owed and 1 month prospective rent in exchange for dismissal of the eviction case. When we do get agreement with landlords to do that, we execute a formal agreement that's enforceable and signed by all parties. I should say we pay full 100% rent, but we don't pay late fees or attorney's fees or court costs or other charges. Next slide, please. I mentioned that we have our template settlement agreements have certain conditions. The first being that the eviction must be dismissed and the rent ledgers brought to 0 upon receipt of payment. When we don't allow landlords to collect those fees and other charges that we won't pay from the tenant. We also have a prohibition on filing a new eviction action for 45 days after the period that we've paid for. So for example, if we settle a case in August and pay September's rent, then a new FED or eviction action couldn't be brought until around November the 15th, even if the tenant had not been able to continue with payments. We put emphasis on the condition of the housing that we're paying assistance for. We make the landlord certify that there's no known defect or condition in the property that affects health or safety. They have to agree to abide by state law and local codes with respect to housing conditions. And they have to agree to allow random inspections by code inspectors. We, in addition to hiring lawyers, we have hired 5 special code inspectors to inspect the properties that we're providing rental assistance for. In addition to that, we require, or we prohibit, I should say, landlords from making negative credit reporting for breaches that have been cured by our payments. And if the tenant is able to keep up and stay out of default after our assistance, landlords agree to negotiate a new lease at the expiration of the lease term. Next slide, please. This is a little bit of information about the impact of our program. Since March, when we began, we have assisted the eviction component, 2,933 households out of a total of 5,337 for the whole program. We have paid, again, the eviction component, $8,324,814 in rental assistance out of a total of $15,662,000 that the whole program is paid. And this statistic, I think, is important. 98.5% of our ERA rental assistance funds have gone directly to landlords. Many of you know that the newest ERA regulations say that if the landlord won't accept rental assistance, that it must be paid to the tenant. Because of the housing situation in Memphis, it's a tight market. We think that most tenants are much better off staying where they are unless they're in unfit housing. And so far, we've only had to pay 1.5% of our funds to tenants directly. And so we feel like that's a good figure. One final point I wanted to talk about was what we call bulk settlements. We have been able to reach settlement agreements with some of the larger landlords that allow us to pay current all of particularly property managers, tenants who are in default on their rent. How that works is that we will offer to some of the larger landlords' attorneys that why don't you go ahead and send us ledgers and rent rolls for all your defaulted tenants. We will reach out to them and invite them to apply for the program and screen them. And if they're eligible, we execute agreements that cover a large number of tenants in one fell swoop. That helps us deal with the large volume of cases that are coming through. Last month in July, we did an agreement that covered 614 tenant households. And we paid $1,270,000, almost $271,000 in rental assistance. And that is a part of a really large agreement that we're working on right now that may cover as many as 3,800 tenants and cover as much as $13.6 million in rental arrearages. So that's the essence of the program, and I'd be happy to answer any questions.
Excellent. That's excellent work, Webb. Really impressive. I just want to let folks know we do have one more panelist, and we're going to go about 10 minutes over if folks have time. If you have to leave, it will be being recorded, so we can always come back later to hear it. I did have a question, Webb, about the bulk payments. I think folks are very interested in that, and I'm wondering how you've engaged the tenant in that process, if at all, when you're working with landlords on the bulk payment. Have you had to get signatures or anything from the tenants to participate in those bulk payment models?
Yes, they have to fill out an application, a formal program application, and do an electronic signature. And again, what we've found, we've done a lot of promotion of the program, but we're constantly still seeing people that didn't know about it. So we feel like we're reaching a whole lot of new people through that. And one thing I neglected to mention, our courts, we included them in the planning, and they've been really good Our general sessions judges now not only will continue cases to allow us to do our negotiation, but if tenants appear that didn't know about the program, they will tell them about it and advise them to contact us. They're very supportive.
Great. That's great. That's so impressive. Thank you so much for this.
Thank you.
Hang on, if you want to take a look at the chat, and there's several questions around the program in there. And Jay, I wanted to just throw back to you that there's several requests for some of your materials and some of the letters. So if you have links to those that you can throw in there, I think folks are very interested in your program in case we don't get to that at the end of the call today. So last but certainly not least, by any means, I want to introduce Greg Payne, who's the director at the Maine Affordable Housing Coalition, who's been doing some really great work looking at eviction data and using that to inform program design and implementation. So Greg, I would love to turn it over to you to talk about some of the work that is happening up in Maine.
Yeah, sure. Thanks for having me. I will do this on kind of speed time here because I think we're now officially over. But so here in Maine, one of the first things we did, last spring when we were trying to begin to get a handle on evictions and how to prepare for what was to come, is we reached out to our court system to ask how we could do that, how we could kind of on a regular basis track what was happening in our eviction courts. And we were a little surprised to find out there was simply no way to do that, short of physically going into every one of Maine's 29 eviction courts and asking for the physical files and walking over to the corner and taking whatever notes we wanted to take and then handing them back to the clerk. That was the only way to actually track what was happening. And so we decided to do that. And we kind of chose the 7 busiest eviction courts in Maine where most of the evictions were occurring. And we went to those courthouses and gathered that information because we wanted to not just find out how many cases were being filed. We really wanted to dig deeper than that to find out why they were being filed and if they were non-payment cases, how much people owed, how many months they were behind, the outcomes of cases, the addresses, who had attorneys, who didn't. We wanted to kind of learn all that. So we ended up gathering about 2,300 eviction files in those courts and put it into a very large database to begin crunching that data and see what we found. And if you want to go to the next slide, certainly one of the things that jumped out at us was the issue that Webb had raised just a minute ago about the disparate representation, legal representation. And so as you can see, it's a little better than what was happening in Tennessee, I gather, but about 80% of the time landlords had the benefit of legal counsel, about 20% of the time tenants did. And if you go to the next slide too, even beyond that, what we found is that tenants were 85% more likely to avoid an eviction judgment when they did have the benefit of an attorney. And so, we took that information as well as other information in the database, and we, ended up bringing that to bear with partners and legislative champions to introduce legislation in our state legislature that just ended recently. And so that legislation had 3 parts, and one of them was an increase in legal services so they could expand their work, because obviously the data was showing us that was a particularly effective way to prevent preventable evictions. The second part of the bill was creating a right to eviction mediation. And the third part was a requirement that going forward, landlords attach a notice, a plain language notice that helps tenants understand how they can access rent relief and legal assistance and housing counseling and get information about the eviction process. So those are the 3 parts of the bill. The right to mediation drew by far the most fire. And the court system itself sort of said, we understand why this would be helpful, but frankly, we're overwhelmed. And as we come back out of the pandemic and start doing things more normally again, we can't handle that. And so we agreed to drop that from the bill with the idea that we might bring it up another time. The piece about funding for legal services, what happened is towards the end of the session, our legislative champions went and met with legal services and our housing finance agency to see if there was a way to fund this expansion of legal services with existing dollars. And the rub here, I think the thing I really wanted to mention is that our legal services folks had real concerns about relying solely on ERA funding. Even ERA 2, there was some real concern about eligibility for their potential clients. And they're concerned about staffing up, hiring 8, 9, 10 new people, and then have a whole bunch of those new clients not be eligible and they couldn't be reimbursed for representation. And so that created a problem that was finally dealt with when our housing finance agency agreed to kind of take a state unrestricted fund and let that serve as a backup. So that to the degree that in the future, as legal services is working with clients and those clients are found to be ineligible for ERA dollars for whatever reason, the state funds are there to back it up and make sure that the payment to legal services can happen. So when that breakthrough happened, we were able to drop the funding provision from the bill as well because it wasn't needed anymore. And that really just left this provision that requires landlords to file this plain language notice so tenants can be aware of rent relief and how to get it, et cetera. And that was signed into law by the governor. And we are working with our partners, landlord side, tenant side, the state housing agency on the language for that notice now so that the specific wording is good to go when the bill becomes effective in mid-October. And the last thing I'll say is that we have in the meantime too been able to work out a month-to-month system with the courts so that we are now getting monthly updates from each of the 29 courts about what's happening in terms of eviction filing so that going forward, we'll know whether it's going to make sense for us to go back to those courthouses and start collecting individual files again and grow that database to learn more about what's really going on there. So I will stop there, Sarah.
Wonderful. Thanks, Greg. This is great. I'm wondering, Greg, I know you have just a minute, but any pointers for folks who are trying to access their data and to look at their data? Like, what do you think are the most important elements that they keep looking at? What do you think helped made the case for this legislation that you would impart on others who are thinking about using their local data to think about policy?
Yeah, I think certainly it was very helpful for us to get a better read on why evictions are occurring. We found out in Maine, it was about 3/4 of cases were for non-payment, and typically it was for 1 to 2 months. And so I think that one of the things that people took from that data was that there may be a whole lot of evictions that are in fact preventable. Mm-hmm. And that sort of guided a lot of, I think, legislative thinking. Clearly the legal representation piece, I think, made its own case. I think that to the degree people can get that from files as well, it's really valuable. Certainly our legislature heard it, saw it, and reacted to it. And that's why we got the money in the end for legal services. And it's enough that I think we're going to have a de facto right to counsel in eviction cases, or at least for income qualified tenants in Maine. And that's huge. So I guess having gone through it and having got on the other side of it, going to these courts is a lot of kind of painstaking work, but it's really worth it. It is, the level and richness of the data that you're collecting beyond just simple how many cases were filed. I think that ends up not presenting nearly enough information about what's going on. It is really worth the time and effort using students, especially as you can, to gather that data and get more out there than simple number of evictions filed.
Awesome, that's great. And that was sort of a question of someone that did ask, how did you fund and who did you use to do that case file research? Was it students, you're saying?
Yeah, a couple of law students did a lot of that work. There was also some undergrad students at the University of Maine who were in pre-law who helped out with that. And so they were a huge part of gathering the data. I would say too, there is this wonderful group that called the National Low Income Housing Coalition that funded much of the work that we did on this. But honestly, it was not that expensive. I mean, it would clearly be a whole lot more expensive if we were hiring, full-time staff to go do it. But having students who could do it we did $20 an hour. And, the truth is you can get through each file in 5 minutes. And, and so with that kind of pay schedule, it doesn't have to break the bank.
Great. That's great. Well, thank you so much. I know we are over time, so I will try to be as respectful as possible of that. But I just wanted to thank all of our presenters today, Greg, Webb, Jay, Samira, Zach, and Christine. You were fabulous. I think we were all leaving here with some great information that we can really use at all. I think it came up at all stages of the process, from pre-filing to engagement, making payment plans from the beginning all the way through to the eviction process and dealing with courts and filings and then collecting data. So I really want to thank all of our panelists. This was phenomenal. If folks have questions, please reach out, let us know. We will be sending these links out later next week in our memo, and they'll be available on our website if you want to go back and listen to them. But thank you all for joining, and have a wonderful rest of your week.